ICC UAE makes it possible.
Good morning to everybody. Thank you very much for joining us today at the ICC webinar on the launch of ICC Publication, a guide to arbitration in the UAE. Thanks to everybody for joining us today. The webinar will be for 1 hour, and we have the original champion of the project today with us, Mr. Ali Al-Daroos, who initiated this project when he was the chairman of ICC UAE Commission on Arbitration in ADR. He will be giving the welcome remarks today. So over to you, Mr. Ali Al-Daroos.
Thank you, Habib. Good morning, everyone. First of all, I'd like to thank you, ICC UAE, and I'm honored for inviting me to this to address the distinguished guest in this roundtable, and the roundtable on the occasion of the launch of a guide to arbitration UAE. Well, the name is a guide to arbitration UAE, but I would say this is more than a guide. It's not a manual. I would say this is a comprehensive and thorough review on the arbitration UAE from the beginning, from the arbitration agreement, all the proceeding aspect of the arbitration and post-award procedure for setting aside and ratification, the award. This is a hard work that lasts more than 2 years. The reason for that, when the task force completed the job immediately, and then the new law of the arbitration law has been promulgated. Therefore, there was a necessary to review, and I thank all the task force who had worked very hard to comment on the new law and to provide what was the position before this law and what the law has bringing to the arbitration proceeding in UAE. I would say this is a quite comprehensive and thorough work, and I take this opportunity to thank you, everyone, and all the task force. And I was honored to work with them, and I will leave the floor to share their valuable input on the arbitration UAE. Thank you, Habib. The floor for you. Thank you.
Thank you, Mr. Ali, for the speech, and thanks for your contribution to the project. Now I'll hand over to the moderator of the session for the day, Dr. Dania Fahas. She will take it from here onward. Over to you, Dania.
Good morning, and thank you, Habib. Thank you, Ali, for the introductory remarks. And it's a pleasure to be moderating this panel today. Good morning to all of you, or good afternoon, depending where you are. As Ali was mentioning, the positive developments witnessed on the UAE arbitration scene over the past years, the latest and most significant one being the promulgation of the new UAE Federal Arbitration Law, number 6 in 2018. These developments have led the ICC to consider a collective publication dedicated to arbitration, to which a lineup of well-established arbitration practitioners, whom we have the pleasure and honor to welcome today on this panel, have gratefully contributed. The long-awaited and the first standalone arbitration law in the UAE. It was, as we all know, modeled after the ancestral model law on international commercial arbitration, and it replaced the provisions of the old UAE Arbitration Chapter in the Civil Procedure Code. It has brought about welcome improvements, bringing the UAE arbitration law in line with the internationally recognized principles and standards, recognizing the principle of competence, and that of separability, expressly granting the arbitral tribunal a wide range of powers to enhance the efficiency in conducting the arbitration proceedings, the role given to the higher courts. All these are welcome advancements that were introduced in this law. Today, almost 2.5 years since its entry into force, we believe it is a timely occasion to make an assessment of the state of arbitration in UAE and to examine the body of case decisions and jurisprudence that has emerged under this law. It is also an opportunity to touch on the areas of uncertainties that were flagged at the time when the law was enacted, and to see whether the judiciary and the UAE state courts have played a role in addressing same in their construction approach of its provisions. The intent of the law was also, as presented by many commentators, to bridge the gap or to narrow the gap between onshore arbitrations and offshore seated arbitrations in reference to the DIFC arbitration rules or the ADGM arbitration regulations. Our speakers will be discussing from comparative perspective if this gap, to what extent it was narrowed, and what are the main divergences that are still existent under the different applicable regimes. It is an ambitious program, but I reassure you, we will not be going through all the provisions of the law. We will be touching on some focal points. And without overdue, I would like to introduce quickly my fellow panelists and welcome them. It's going to be a very brief introduction, only by the title, but as I think all of them are familiar faces to most of you who are attending today, I think I can get away with it. I will start with Gordon Blank. Dr. Gordon Blank, he's a founding partner at Blank Arbitration in Dubai. On the screen under Gordon, Alain Farhad. Alain is a partner and the head of litigation and dispute resolution at Mayer Brown in Dubai. Next to Alain, Dr. Hassan Arab. Dr. Hassan Arab, the chairman of the ICC UAE Commission on Arbitration and ADR. He's the partner and the head of litigation at Tamimi & Co. In Dubai. Mahmoud Hussein, he's the vice chair under Hassan, and he is the vice chair of the ICC UAE Commission on Arbitration and ADR. Mahmoud Hussein is also a founding partner at Mahmoud Hussein Law Firm. And last but not least, Philippe Pounoir. Philippe Pounoir, he is a partner at Baker Botts in Dubai. Welcome all of you, and I look forward to an interesting discussion around the new arbitration law and the jurisprudence that has emerged since its entry into force. Let's kick off the discussion with Philippe. Philippe, it would be appreciated if you could give us an overview, a contextual overview around this new arbitration law, and maybe also shed the light on some of the ambiguous provisions that maybe would need to be addressed in the future. Philippe, the floor is yours. You're muted.
I promise I did press that button, but it didn't work. So here we are. Thank you very much indeed, Daria. It's a pleasure to be given the opportunity to say a few words about the new arbitration law. One of the things I'd like to stress is that we've been waiting for this law for a very long time. And it's worth noting that the subcommittee who worked on drafting the DIFC Arbitration Law 2008 were very conscious of the fact that it would be preferable if the DIFC Arbitration Law, as amended in 2008, was largely consistent with any federal arbitration law that might be introduced. And as there was a draft federal arbitration law being circulated in 2007/2008, the DIFC Arbitration Law 2008 actually took on board quite a few provisions found in that earlier draft. And it seems to me, having been involved in both of those laws, that the new law we have does carry over some aspects of the 2007-2008 draft arbitration law, federal arbitration law. And I imagine those who have looked closely at the law will also see that there are some obvious similarities between this law and the Egyptian arbitration law and also the Saudi Arabian arbitration law. But having said that, as I said in my chapter, it is a law that requires careful scrutiny because there are some peculiarities. But as you've rightly said, Dania, this is an arbitration law that's based on the UNCITRAL Model Law 1985, and it removes an awful lot of the uncertainties that practitioners operated under for the 26-year period that we were operating under the very few provisions of the civil procedure law on arbitration, the 15 or 16 or so provisions. So there's no doubt that this is a huge step forward for us in the UAE. From my point of view, I think what's really refreshing about the law is the manner in which the court's role is addressed, and the steps that are taken not simply to permit arbitration in the UAE, but to actually actively facilitate arbitration. And in that regard, it's I think extremely welcome to see that it reserves arbitration matters pretty much exclusively to a single judge of the Court of Appeal. A judge can reach out to any arbitral institution in the UAE and request a list of arbitrators. And that, of course, benefits the parties, because on previous occasions under the previous legislation, if you were a party in a proceeding where there was going to be a default proceeding made by the court, you really had absolutely no input at that point, and the court would make an appointment from the list of experts held by the court. But here, the judge can reach out to the arbitral institutions, and that must be good when it comes to the quality of appointments. And of course, as you touched on, the new law massively clarifies and I think expands upon the powers of the tribunal. And in that regard, I think anyone who reads this law will be pleased to see that the power of the tribunal, the inherent power of the tribunal to order interim and precautionary measures, is now very clearly to be found there in the law at Article 21. And of course, given the nature of the environment in which we operate, where we regularly are advising in respect to very large multi-party projects, it's also very good to see that the tribunal has the power on an application of a party to join another party to the proceedings, so long as they are a party to the arbitration agreement. There's also a provision in the law, which I'm sure will be touched on by others, probably Alain, whereby it's now made clear that the tribunal can order interim and partial awards. And it's also spelt out in this law that the tribunal no longer has to suspend its proceedings where a matter arises that's outside its jurisdiction, or where there's an allegation of forgery, or where a criminal prosecution has been filed that touches upon the dispute. These are all to be expected in a modern arbitration law, and they are in this arbitration law as well. I shudder to think what would have happened if we didn't have this new arbitration law by the time COVID struck, because I think we would have been struggling. And it really doesn't bear thinking about. But what is also noticeable about the new arbitration law is the extent to which it facilitates modern hearing practices, remote hearing, for example. So we have a provision that hearings can be held through any means of modern telecommunications. We have a provision that now makes it clear that the tribunal can hear experts and witnesses without them being present. And there's a provision which arguably enables the oath to be dispensed with in proceedings. But that's one of the areas I suggest where some clarity may be required, because it's potentially ambiguous, it seems to me. And also, the arbitration law does its bit also to save the planet, because we now have a provision that makes it clear that arbitrators don't have to fly across the world to the UAE to sign an arbitration award. The arbitration award is now deemed to be issued at the seat, i.e. in the UAE, regardless of where it's signed. And we have a provision that deals with the electronic signature, the use of electronic signatures in awards, and also a provision that permits awards to be issued in original and copy format, of course, extremely important in the COVID age. And for my part as well, I welcome the provision that makes it clear that the arbitration agreement survives the nullity of an award, which I think is a very helpful addition. Yes, there are ambiguities, as I've touched on, and others will doubtless explore. For my part, for example, it's not entirely clear what the costs provisions amount to, or the confidentiality provisions. There'll be a lot of debate as to the role of public policy when it comes to challenging awards in one way or another. And for my part also, I'm still somewhat perplexed until someone explains to me what the consequences are of the commencement date of the arbitration being the day after the constitution of the tribunal. There are a number of provisions which do obviously depart from the UNCITRAL model law. One is regarding the default language. That's not within the power of the tribunal to decide now. The default language will be automatically Arabic. So overall, as I've said in my chapter, I think it's an honest application of the UNCITRAL model law, and it's largely successful. But there are ambiguities which will need to be explored and ironed out by the courts in due course.
Thank you, Philip, for this broad overview. It is clear that this new law has provided a secure and progressive framework for arbitration proceedings, despite some shortcomings that are expected to be addressed in the future and maybe by the state courts. I would like to dig into more topical issues now and start with the first topical issue, the arbitration agreement, the validity of the arbitration agreement. If we look at the provisions of Chapter 2 of the arbitration, of this new arbitration law that deals with the arbitration agreement, we see that the requirement for the arbitration agreement to be evidenced in writing is maintained. We note also, and we welcome the express provisions providing that agreements can be entered into by any means of communication, including by email. This is in line with the UNCITRAL law, and this is of great relevance in current times under COVID-19. And also it is something that reflects that this arbitration law, the role and emphasis given to technology, is something that we can welcome actually, and proved to be quite relevant during these times. Welcome improvements. The incorporation by reference principle is also expressly recognized, and the principle of separability, another cornerstone principle, is expressly recognized in the new law. Just a few words regarding the principle of incorporation by reference provided for in Article 5. This principle is recognized provided there is a specific mention of the arbitration clause contained in the reference document. The construction of this provision by the judiciary and how it relates to the historical view of the arbitration, Hassan, being an exceptional means of dispute resolution. And we might see rather here an exaggerated focus on formality. Hassan, can you weigh in on this point and share with us what is the stance of the judiciary today regarding this point in Dubai and Abu Dhabi?
Well, thank you, Dania, for the introduction you gave about this chapter, and many thanks for the ICC UAE for inviting us for this event. It's an honor to be part of the distinguished panel. The reason, actually, the arbitration agreement, it's an important topic. It's the backbone of the arbitration. And the reason basically why I focused on this, as you know, the arbitration agreement, it confirms the parties' wish to arbitrate their disputes. This is one of the reasons. The other reason, it's a waiver of immunity from the jurisdiction of the national courts. The third reason, it established the jurisdiction of the arbitration tribunal. There is a lot of improvement with regards to the new arbitration law. We used to have a lot of issues when it comes to the arbitration agreement with regards to the capacity of the person, especially with the companies. Actually, most of the companies here, as you know, actually they've been represented by their a person who's a manager or a director. The issue of the capacity of that person to sign on behalf of the entity was a big issue, and we had so many many decisions where the court and the practitioner were very disappointed with the court's outcome, where they annulled the award due to the lack of the capacity. I believe with the new law and with the new trend by the UAE courts, there is a huge improvement with regard to the arbitration agreement and the capacity of the person who signed the on behalf of the entity. We've seen that the previous challenges to the capacity, the court is dealing with this challenge in a smart way. And they linked even the challenge with some other principle, like the good faith, that you cannot basically participate, the party cannot participate in arbitration and later on decide to challenge that the person who signed on behalf of the entity doesn't have the capacity to sign. This argument is not anymore a valid argument with the recent decision. Many decisions actually by the Dubai court, they are in line with the best practice. One of the things also I noticed before the new law come into force, a decision by the Court of Cassation in Dubai, and it's in line with the new law, by the way, about the capacity when the seat of arbitration is outside of the UAE, whether they will consider the UAE laws and regulation or the law of the seat. The decision was, this is the only decision maybe I've seen issued by the Dubai Court of Cassation. They were very strict and they were in line with the New York Convention as well, that when you look at the capacity of the person who signed, you should consider the law of the seat and not the law of the UAE. And I believe it's in line with the Article 53 of the new law. Overall, I can see that the trend is very positive with regards to the arbitration agreement and the capacity of the person who signed on behalf of the entity. The principle of severability, competence, it was actually even before the law. We had these principles issued by the court. However, actually the previous provision of the arbitration doesn't cover those principles. But the Court of Cassation and the higher court in UAE in general, they highlighted these principles. So overall, I can say that in summary, it's a positive position. I believe there is, as Philip said, there is some provision need some more clearance because there is ambiguity. I cannot say that it's a clear law. There are some provision need, and there is a huge role on the higher courts in UAE to clear some provisions. I have some examples actually with regards to when we will talk about the interim measure, for example, the power that they gave to the arbitrators. We'll mention and we'll highlight some recent decision which confirms that UAE is supporting arbitration, and the courts, they are getting very friendly with the arbitration.
Thank you, Hassan. However, we can still confirm that the requirement for a special authorization and power of attorney for an entity, for its representative, it's still maintained depending on the form of this entity. And this is something that also should be pointed out, that it was maintained under this new law, and the jurisprudence and the case decisions emerging lately confirm the need for such a specific special authorization. Gordon, would you like to weigh in on that?
Yes, Danya, thank you very much, if I may. I think that particular requirement, in a sense, and I think Hassan intimated it in his presentation, has been alleviated to some extent by the court's acknowledgement and recognition, as a matter of fact, of the application of the doctrine of apparent authority to the formation of arbitration agreements. I think that's extremely important. This set in already in 2015, 2016 under the old regime, the UAE Arbitration Chapter, and has been successfully carried through into the application of Article 4.1 of the new law, and I think needs to be emphasized in this roundtable. So apparent authority is now a staple, as a matter of fact, of the capacity assessment under the federal arbitration law. Thank you, Rania.
Thank you, Gordon. Moving on to the duties and the powers that were recognized to the arbitral tribunal under this new law. as we were mentioning, to enhance the efficiency in conducting the arbitration proceedings. Another welcome improvement under this new law is the express recognition of the tribunal's authority to rule on its jurisdiction, what commonly known as the principle of compétence. This principle is recognized at Article 19 of the new law, and it provides that the arbitral tribunal can rule on its jurisdiction either as a preliminary decision or in the final award on the merits. When the arbitral tribunal rules as a preliminary decision on this issue, this decision can be subject to a review. What are the conditions for the party to submit its review, and how these conditions play into practice, knowing that there is a specific timeline, which is quite tight in practice, to submit this review, 15 days, and the effect regarding the stay of the enforcement, the stay of the arbitration proceedings. Can you just give us what do you make of this article in practice, from your practice, and how does it mirror the provisions that we might find in the arbitration rules or regulations in offshore jurisdictions?
Good morning, everyone. Thank you, Dania. Just allow me, perhaps, before answering your very interesting question, to take a step back, also to thank the ICC UAE as well as the ICC in Paris for making this book possible, and this event, which is intended to promote the launch of this book, possible. As you probably all know, this is probably the first comprehensive book on arbitration in the UAE since the launch of the UAE federal arbitration law, and I'm delighted to have contributed to it with my fellow distinguished contributors. I also wanted to say a word to thank Mr. Ali Al-Aidarous, who you have all heard from a moment ago. Ali was the inspiration behind this work as the former chairman of our ICC UAE National Committee. So thank you, Ali. Now, going to the question you asked regarding the principle of compétence in Article 19 of the law. As Hassan, I should say Dr. Hassan, mentioned a moment ago, the UAE courts had previously accepted the principle of compétence through a variety of court decisions. There wasn't much of a debate left on this issue, but the law provides the benefit of codifying what the courts had already decided by making perfectly clear that arbitral tribunals have the power to decide on their own jurisdiction. And I should add that, because it doesn't seem to be entirely clear for everyone, that when an arbitral tribunal issues a decision, an award on its own jurisdiction, that is res judicata. The arbitral tribunal has decided the question of jurisdiction, so you can't go then to court and ask again the question of jurisdiction. What you can do is, within 15 days of that decision having been rendered, challenge the award on jurisdiction. And the great benefit of that, Dania and colleagues, is that previously, under the previous regime, under the CPC provisions, parties sometimes kept their argument against an award on jurisdiction in their pocket, waited for years for the award on the merits to be rendered, and then attack the final outcome of the arbitration, having delayed things and waited for a long time, based on a challenge against the award on jurisdiction. So this really forces parties to make their position perfectly clear. If they're dissatisfied with a decision on jurisdiction, they have 15 days to make their challenge known.
Just read in conjunction with Article 25, where the new law expressly recognizes the waive of objection right. I think this article also can interplay with what you just mentioned, that a party cannot use this dilatory challenge later on down the line, because it would be assumed that he or she waived the right to object once they engage in the arbitration proceedings. So it's worth also highlighting Article 25, which brings some certainty also to this issue.
That's correct. So 25 is the overall, overarching concept that if you have an objection, you have to make it known, or a challenge, you have to make it known immediately or within a reasonable time frame, not keep it for when the final award is rendered, which was the case previously. For example, if you have a cause of complaint against one of the arbitrators, or due process, or the way the proceedings are being conducted, you have to communicate it when it's known to you. You can't just say, oh, 3 years ago, we didn't get a chance to say something we wanted to say at the hearing. So so that's very important. Article 19 is the same logic, but with respect to challenges to jurisdiction, which is, as I said a moment ago, very, very helpful. Another key aspect of Article 19, if I may, Dania, is that previously parties challenging an award on jurisdiction sought a stay of the proceedings on the merits. So they said, oh, you rendered a decision on jurisdiction. We don't agree with it. We don't want to waste costs. So you're going to have to stay proceedings. And sometimes under the previous regimes, tribunals hesitated. They weren't sure what to do because this was not covered by the small number of provisions of the Code of Civil Procedure. And so now it's perfectly clear that the tribunals have the choice of continuing the proceedings as long as one party so requests. So presumably the party that has benefited from the award, the winner of the award on jurisdiction, will request continuation. The other side may try to delay things by saying proceedings should be stayed. Now it's perfectly clear that the tribunal has the power to continue against and over the protests of one of the parties, as long as the other one so requests. I think Gordon has raised his hands.
I apologize for raising my hand. I just want to add one clarification, if I may, Alain. If I understand correctly, the challenge regime under 19.2 only applies to awards affirming a jurisdiction of the tribunal. If one were to have a negative award on jurisdiction, that would be a final award, ultimately terminating the arbitration process as well, and would be possibly challengeable under the regime that applies to, well, final awards ultimately.
Thank you, Gordon. It's worth mentioning that actually there is a time limit of 30 days here in practice. I wonder how this is playing out in practice, if in reality, actually, we can expect a decision in 30 days. Anyone?
My anecdotal feedback is that it takes longer than 30 days. But what really matters here is the 15 days for the party who wishes to challenge to do that. The 30 days, obviously, courts may take longer, but perhaps Dr. Hassan or Mahmoud have further input from their experience with the courts.
I'm afraid maybe, Hassan, would you like to comment on that? Maybe we're dwelling too much on this question.
Yeah.
Actually, to
no, it's fine. I agree with the Gordon in his understanding of this article, actually, Article 19.2. In fact, there was a recent example, and I was trying to talk when we will talk about the consolidation, where the tribunal actually decided in his final award to dismiss the case due to the lack of jurisdiction, and the parties, the party who challenged the decision, he approached the court based on the normal annulment provision, which is Article 53. And then the court basically, I would like to highlight this in the maybe more in the when we will talk about the consolidation. They decided that the tribunal, they have the jurisdiction actually, And maybe I will highlight more about the facts because it's very interesting. It's one of the major development in UAE. We hope that we will see the confirmation of this decision by the Court of Cassation.
Absolutely. We're getting to actually join there, Hassan. Yes, Gordon.
Apologies for another intervention. I'll be brief. Just to be sure, as far as I'm aware, the courts have decided that any of the timelines that apply to the courts, the exercise of the court's obligations, the courier court's obligations under the new law, and there are quite a few, including, for example, the 30-day time limit for rendering a decision on the challenge under 19.2, are regulatory and not mandatory, even though the language of the article is cast in mandatory terms. They normally use shall, i.e. the court shall render a decision, decide, and so forth. The courts have decided that this doesn't apply strictly. It's a regulatory time limit. And I've had the experience in one of the first cases, I believe, under Article 19.2 before the Dubai courts, that the court took about 3 months, I believe, rather than 30 days to turn the decision around, but then did decide that the tribunal wrongfully attributed jurisdiction to itself and set aside that award on jurisdiction. Thank you.
Thank you, Gordon.
Again, I don't know why I'm in agreement with Gordon today. Another example actually we have is something similar actually. The enforcement of the foreign arbitral award under the cabinet resolution. The execution judge should decide within 3 days on the application, but in practical, it will take 3 weeks.
I agree with both of you as well. My practical experience shows that in some instance, actually, the challenge took 4 months. With the foreign arbitral award, I have seen maybe more than this, 1 month or 1.5 months. And some surprisingly, sometimes the judge called the clerk of the court, asked us to provide more information for the judge because he wants certain element or certain document, which I thought it was irrelevant for the issues, but the thing is the judge wanted it to make him comfort. So basically, but I'm seeing the trend, but most of, we say 90% of the cases finish within the time frame, but there is 10% of the cases, because although I have seen 4 months, I have seen most of the cases fall within 3 weeks to 2 weeks. This is the parameter. So there is a 10% outside of this scope. So basically, as Gordon say, they are not looking as it is as a mandatory law, but they are looking at it as a regulatory framework to encourage them to finish it within 1 month. But however, the court can take 2 months or 3 months. So basically, I agree with you. They are not looking. Although my reading for this article, I think it's a mandatory law. It's obligation on the courts to finish within the time framework decided in order to expedite the process of arbitration. Hopefully, we will see more judgment coming from Cassation Court elaborating in this point. But I don't know how they would be what they would do with the judgment when the judge will issue the judgment within 3 months. Let's say, would he nullify his judgment? Would he do other thing because of the procedural mistake from the judge, with the party didn't have any hand to it? So I don't know how Cassation Court will deal with the issue.
Thank you,
and Dania, if I may just to add to this, overall, I think we can conclude that it's a positive development and it's an improvement over what existed before. Even if you have the outlier cases where it can take longer than what's envisaged in the law, in a large number of cases, they do actually comply with the limited the time frames.
Yes, thank you. And I would like to move on just to actually illustrate that way and focus on more other topical issues. And another procedural tool also that was recognized to the arbitrator is the power to issue interim orders. This power was not expressly granted under the old regime. And actually, the Abu Dhabi Court of Cassation had a strong position against recognizing the power for the arbitrator to order interim or conservatory measures in the absence of an express agreement of the parties and the main contract. Article 21 of this new law sets out expressly and lists a list of the interim measures that the arbitral tribunal is entitled and has the authority to order at the request of the party or at its own motion, This list, to a great extent, mirrors the list under the ancestral model law. Alain, can you please just walk us through the conditions and the regime that govern actually the application by the party seeking a conservatory measure or an interim measure from the arbitrary tribunal, and how these provisions do apply, and how also maybe there are some divergences that we find when we look at the offshore arbitration regulations in this respect.
Thank you, Dania. Well, again, let me take a step back. You just mentioned it, but under the previous provisions, we didn't have clear guidance on whether or not arbitral tribunals could issue interim measures. The courts had, on a number of occasions, decided against awards where there were interim measures, and they had confirmed in a way that the absent agreement of the parties, no such power existed for the arbitral tribunal, which means that parties seeking interim or conservatory measures had to go to the courts. Now it's perfectly clear that that power exists under the UAE federal arbitration law, unless the parties contract out of it. That's a possibility, but the parties can contract out of it. It's also a concurrent power with the courts. So it's not exclusive. So you can still go to the local courts where the seat is, and you can also, and sometimes you need to go to the local courts where the seat is before the arbitral tribunal is constituted. And so you have no other option, because in urgent situations, you only have before the tribunal is constituted, you have to go before the local court. I believe, Mahmoud, you should mute yourself. Mahmoud, you're not muted.
He is now. Please go on.
Thank you. That was really an issue for tribunals, for parties. Very often, when faced with a request for interim measures by one party, the other party would simply say, sorry, members of the tribunal, you don't have that power. And so you would end up with long debates and arguments about whether or not that power existed. And the argument went even further, because the question was whether or in institutional arbitration, where the rules of the institution provided for that power, whether a simple reference in the arbitration agreement to the rules of that institution was sufficient to constitute express agreement to give the tribunal such power. And so that resulted, again, in endless debates. Often parties went around that problem by providing it in the terms of reference when there was terms of reference, providing expressly that tribunals had the power to issue interim measures. So now the question is resolved in a way. We know that tribunals have that power, so all this unnecessary debate is taken care of. The question that remains is whether, and so the under the new law, a party, the beneficiary of an interim measure ordered by a tribunal, can take it to the courts for immediate enforcement, which is also a nice feature of the law. Now, the question is whether the courts in the future will simply take that decision and accept it and enforce it, or if they will want to have a de novo review of the interim measure and have the parties argue again that the interim measure point. So, and again, it may be a question for Dr. Hassan or Mahmoud to answer. I see Dr. Hassan raises his hand.
Well, thank you, Alan. I would like to share my experience, actually, which shows how there is a huge improvement with the court. I had an application for the interim measure, and I approached the summary judge, who refused to deal with the application and said, obviously, that either you have to obtain the decision or the order by the Chief Justice of Appeal or the tribunal. I don't have a jurisdiction. Not only this, actually, we have two decisions by the Dubai Court of Cassation in 2020 and in 2019, confirming that the tribunal and the Chief Justice, they have the exclusive jurisdiction to issue the interim measure order. It is a huge improvement. It's a positive step. And as I said at the beginning, actually, there is a huge role on the higher courts of UAE to clear and to let us move one step beyond the law itself by the positive decision similar to what I mentioned.
Yes, and it's very actually comforting to see that the principle of limited court interference has finally found its way to federal courts. Yes, Gordon.
Just a quick follow-up question to Hassan, please. Can Hassan also confirm that there's actually, contrary to Alain's concerns, no de novo review of the actual ground for the interim measure before the courts? I believe when you look at Article 21.4 that deals essentially with the enforcement of interim measures rendered by arbitration tribunals before the courts, it says very clearly that this is subject to permission being granted by the arbitration tribunal, which makes me think that probably the courts will not want to do a de novo review in the first place. But you know, it would be interesting to hear from the advocates in the round, both Mahmoud Hussain as well as Hassan Arab, Dr. Hassan Arab, as to what their experience is on that front. Thank you.
Thank you, Gordon.
And didn't Hassan just confirm that there was no?
Well, if I understand
in his experience, I think
Yes.
I think that's what you said previously. Yeah, there is no de novo review in your.
I didn't catch that. If he said that, then I thank you for it. I didn't catch that. Sorry.
He confirms this.
Yes.
Instruction. We move on.
Maybe if I may say one other, or give one other note on this, which is Article 39.2, which is in wider terms essentially, and provides in relevant part that interim awards of the arbitration tribunal are enforceable before the courts through an order issued on the basis of an application by the Chief Justice of the Court and whoever he delegates for that purpose. I think that again confirms Hassan's experience. The interesting issue that's raised by this particular article is when you look at the preceding article, 39.1, that deals with the tribunal's power to issue interim awards, but also partial awards on part of claims before rendering the award, ending the entire dispute. So awards that are partial in nature are not final in that sense. Well, it could be final partial awards or partial final awards, but so be it. Now, the interesting thing now is that wording, i.e. awards on part of claims, does not appear or reappear in clause 2.
Exactly.
And the question that arises is simply as to whether the legislator intentionally confined paragraph 2 of Article 39 to interim awards. Now, my answer to that would be I doubt it, for the simple reason that an interim award is the lesser of a partial and an interim award. A partial award decides matters not only as a temporary or temporarily, but definitively on the merits. Possibly it could be a liability award, could be an award on jurisdiction, possibly, and from that point of view, possibly would subsume as well partial awards. So if the courts have the power to enforce interim awards, a fortiori, they must have the power to enforce partial awards. But again, I defer to both Mahmoud and Dr. Hassan on their own experience on this subject. Thank you.
Yes, thank you, Gordon. You touched actually on my next question, which was whether this silence on the partial awards is intentional by the legislator or is just an omission that is actually justified by the principle of a fortiori. Hassan, I understand you unfortunately would need to leave us. Thank you for joining us, and thank you for bringing to us these insightful decisions that have emerged recently from the federal courts here, and we hope to see you again very soon. Thank you again.
Thank you so much. Thank you, my colleagues.
We move on under the proceedings. I would like to touch on another procedural issue, which is actually the conditions for administering oath and taking oath, witnesses oath. Gordon, I know you have some insights to share with us regarding this this issue, and I know that this is sometimes a point of contention under UAE law.
Yes, Dania, absolutely correct. I mean, certainly under the UAE Arbitration Chapter, we had an express provision that provided for an obligation to administer the oath to testifying witnesses. That was Article, I believe, 211 of the former UAE Arbitration Chapter. Now, importantly, the courts, even at the time, were very clear on saying that the importance of witness evidence taken on oath is that arbitrators are limited to only such evidence, or if arbitrators want to take into account any witness evidence during the arbitration process in their deliberations, they can only do so if that witness evidence has been taken on oath. Now, to the extent that arbitrators don't rely upon that particular evidence, then it doesn't really matter, and an award won't be able to be set aside because it will naturally not rely upon that evidence in the first place. Now, under the new law, we've lost that provision 211, and the question that simply arises is as to whether the legislator did so on purpose, or whether indeed, possibly, the legislator thought there was no need to include that provision, because under old case law precedent, it's arguable that the oath-taking requirement qualifies as a procedural public policy in the UAE, and therefore finds its way into application under the new law by dint of public policy. So I think that's really what is at stake at the moment. There hasn't been any conclusive case law precedent under the new law, as far as I'm aware. I think there's been some watered down, diluted version of a judgment that touched upon the issue of the deliberations of the tribunal and arbitration award not taking account of particular witness evidence, and therefore the unimportance or irrelevance of the oath-taking exercise. But no particular commitment by the courts either way to say that under the new law there is no oath-taking requirement, or that there indeed is. But maybe Mahmoud could shed some light on the public policy notion of the oath-taking requirement, and to what extent that may well be an or an avenue of reasoning for the courts moving forward on that front.
Thank you. Thank you, Gordon. Before moving to Mahmoud, it's worth also highlighting that the award would be annulled if the ruling of the arbitral tribunal was based on the witness testimony. This is something that is worth also underscoring. The ruling of the arbitral tribunal should have been based on the testimony of the witness who failed to actually, to whom they failed to administer the oath taking.
I believe that's correct. Yes, I believe that's correct.
Mahmoud, I would like to have your view actually regarding the issue of public policy and how it relates to procedural law. We know that the reference to public policy in this law was in a different wording. It's public order and morality of the state. In this new law, we have this reference being made in 3 instances. One at Article 53, paragraph 2, regarding the challenges to obtain the annulment of the award expectedly. Another instance is providing for this as a limitation for the party's choice of the law applicable to the substance of their dispute. And another last instance, which is less expectedly actually, is with respect to the arbitration law provisions applicable to the proceedings when the parties choose the procedural law other than the UAE federal arbitration law, providing that this law should not conflict with the public order and public morality. I would like to touch on the procedural law with you and how it relates to public order and state morality, and maybe also to link it to Sharia, as we know Sharia is a primary source for legislation in UAE. Mahmoud, to what extent do you think the principles of Sharia do converge with the internationally recognized principle of due process?
Thank you very much, Dania. Thank you very much for the panel, actually, for this lively session. Actually, the concept of public policy is still problematic in the context of the newly established arbitration framework. It is not changed since the new law. The view has not been changed by the court jurisprudence. So basically, the problematic issue is that the UAE concept of public policy consists of two elements. Element one is the public interest, and element two is Sharia or Islamic law, whatever you call it, although they are different terminology, Sharia and Islamic law. Public interest in a context of UAE public policy is largely driven from national laws, social, political, and economic norms and values of the countries. So basically, it's a very broad, it's a domestic public policy. It is not international public policy. It is not transnational public policy. So basically, the concept is purely it's a notion of public policy, domestic public policy. So it consists, as I said, social, political, economic values of the country. While Sharia is another element of public policy, which is generally driven from interpretation and thought of Islamic Sharia, Sunni Sharia jurisprudence. So that's two elements of public policy, and both of them they play. And there is interplay between the two of them. And both of them, so Sharia frame the concept of the public policy, because the interpretation of the UAE laws comes from Sharia as well. Because if the judge didn't see a specific law, he would go for Sharia to interpret the law or to fill the gap in the legislation. So basically, all of the two elements, they play. However, the public policy in the context of Sharia will raise more complex and significant challenge than those relating to public interest. Because when you go to the public interest, as I said, the social, public, you feel them, you touch them, you can control them actually to a certain level. However, when it comes to Sharia, you cannot control them because the complexity is very big because of the fact Sharia is not codified law. Because it's not codified law, so therefore, the interpretation of different judges, different Sharia scholars, which has led to various interpretations, sometimes conflicting interpretation of Sharia. Within the same courts, you would see one will take the jurisprudence of scholars, for example, Maliki. Within, for example, Maliki, Sharia jurisprudence, there is 6 or 7 schools as well. Each of a student of Imam Malik. Imam Abu Hanifa is well-known scholar, al-Shaybani, has different opinions sometimes he's a scholar, the main scholar of the school. So that's the reason it's become more exaggerated, become more intense, and this divergence of interpretation of Sharia has led to conflicting. My expectation, it will not change under the new law, because my expectation was that the legislator should have little bit massaged the public policy, should have defined international public policy when it comes for international arbitration award, domestic public policy. But with this definition, when you see it in the Cassation Court judgment, you would see everything. It can fit anything. You say the mandatory laws, the social, and all of that. Therefore, from my perspective, when I read I see the jurisprudence and even the interpretation of Sharia by the Cassation Court, the oath shouldn't fall on that. Because why? When the oath is not part of mandatory laws, it's not political or economic or norm value of the country, in order for you to depend on it and say no. I think the court would come to new opinion about that, because it was exaggerated, because it was open area and they could interpret. I think with the new interpretation, if they follow their own definition of public policy of the Cassation Court, shouldn't be part of it. And this is why I always argued with the courts, with my colleagues, that oath shouldn't be part of public policy. It's not part of social, political, economic norm and value of the country. And this is the definition of Cassation, where you will fit the oath. So it is not. Now you come to Sharia. In Sharia, it's defined to two, public policy is 2 elements, which is procedural Sharia public policy and substantive public policy. Procedural public policy, it's a due process, because Sharia doesn't doesn't recognize procedure, leave it to the administrative of government. But usually Sharia insists that the fairness due process. So basically it does not conflict with the international best practice of due process and fairness. However, the challenge is the substantive Sharia public policy.
And we get to, yes, I think we'll get to the substantive part later on. Thank you for pointing, yes, Mahmoud, thank you for pointing out.
Yeah.
Sorry to interrupt you, because we're getting to the substantive part in a bit. I wanted your input regarding the procedural part, and it's very much appreciated that you mentioned the principles of Sharia do not contradict the generally and universally recognized principles of due process. When we talk about fairness, it relates also to the duty to give the parties the opportunity to be equally heard, to present their evidence, the impartiality. All these are quite universal principles that also are upheld by the Sharia from a procedural point of view. Do you agree with this reading, Ahmed?
I agree with this. However, there is a confusion between in UAE law between the procedural public policy and the due process. So it's a conflicting, because a due process in some jurisdiction is a procedure. You need to raise it. However, we have seen the court raise it with own motions, without the party raising it. So basically, there is distinguish. We should always, even if you look to the New York Convention, you would see the procedural due process is not part of the public policy. However, they might impact it. So basically, there is a confusion because the court will look to it as a public policy. Always the procedural aspect, fairness, administration of justice, which is so broad, defining procedural public policy, which is beyond what is expected internationally. Because that's why we see the court tendency is to put the oath part of the public policy. Why? Because they think any procedural of administering justice is a part of the public policy, whether it is a fundamental or not fundamental. So they consider. So the mentality of judge has to be changed down with a new law, looking to the procedure and defining what is the procedural public policy, what is substantive public policy. We have confusion on procedural public policies. Everything is about administering justice, the process of the court is a public policy, which is wrong. It's not. It could be mandatory law. It could be mandatory law, but it's not public policy. However, we put it in one bandura. It's a public policy. Even the court doesn't speak whether it's a procedural public policy and how they can conclude it to come to this conclusion.
Thank you, Mahmoud. Thank you. And thank you for raising this nuance regarding the possibility for the court to raise the ground for annulment at its own motion. And this is something that is expressly provided for under paragraph 2 of Article 53 and was also raising some controversy among the commentators, why there is specific mention on its own initiative. This is the wording under paragraph 2 of Article 53, stating the grounds for annulment, and one ground is expectedly public order and morality of the state. Thank you, Mahmoud. We move on now to the award. I think we're running short on time, but it would be maybe a way to close before touching on the awards. Thank you for all the panelists for making the time for joining us today. It was a fascinating discussion. We have not touched on all the issues that we would have loved to touch on. The issue of legal costs and the award, for example, it's a point of contention. I'm sure any one of the audience who would like to take the conversation further can reach to any of you. The publication is available also in a digital and a hard copy format. In the welcome message, you have the links to order the publication. Thank you again for the authors for joining us. And one main conclusion for this discussion is that it is undoubtful that this new federal arbitration law has reshaped the landscape of arbitration in UAE towards more efficiency and towards more certainty. And we will be at the outlook for the to see what the judiciary will be making out of these provisions, and how they will be upholding the principle of international arbitrations in line with the aspiration of UAE to be a regional arbitration hub. Finally, I would like to thank Habib for his precious assistance, and ICC UAE, our partners, ADGM, our strategic partner also, for helping us to bring this webinar to all of you. I wish you a pleasant afternoon or evening, and thank you again.
Thank you. Thank you very much.
ICC UAE makes it possible.